Okay. So hi everyone. Good afternoon, good morning, good evening, depending where you're joining us, and welcome. My name is Vincent Lefebvre. I am the co-chair and legal compliance director at Generation for Rights Over the World. And I'd like to begin by warmly thank all of our speakers and moderators for joining us today, and also to you attendees for your interest in the topic that we will be tackling today. This event is taking place in a context where strategic lawsuits against public participations, also known as SLAPPs, have emerged as a significant and growing threat to democratic engagement in France and beyond. And it is a topic that is extremely, I would say, a hot topic in Europe, with different legislation arising in different jurisdictions and at the European level. It is the first event of a series of 3 events that we are organizing under the Building for the Future initiative, coordinated by Think Tank and supported by the Open Society Foundations, to amplify youth-driven, diverse perspective, advance innovative policy solutions across Europe and beyond, and encourage the exchange of good practices among regions. The aim of this series is to reframe local policy debates on SLAPPs in France through a comparative lens, and as such, we'll be drawing lessons from jurisdictions that have developed, tested, and refined different anti-SLAPP mechanisms, namely Canada, Mexico, and Indonesia. At GROW, freedom of expression is a topic that we have tackled in the past, and notably through our advocacy for stronger compliance by France with ECTHR judgments, so judgments of the European Court of Human Rights. And this event builds directly on that foundation, aiming to translate comparative international insights into concrete policy recommendations tailored to the French legal and social context. So I will now briefly introduce our moderator speakers for today's discussion. So we are honored to have with us Zuzana Novica. Zuzana is a lawyer at the Freedom of Speech program of the Helsinki Foundation for Human Rights. So it's a human rights organization based in Poland. And she will be guiding our exchanges as moderator. Joining us from Canada, James Turk, Director of the Center for Free Expression at the Toronto Metropolitan University, who will offer a comprehensive overview of the Canadian experience with anti-SLAPP legislation. We will then turn to the Latin American perspective with Lady Nancy Zuluaga Jaramillo, Senior Legal Researcher and Project Coordinator at the Business and Human Rights Resource Center, who will delve into the Mexican context and the regional developments. And finally, Yogi Bhattacharya, legal consultant and member of the Asia Pacific Youth Advisory Group on Environmental and Climate Justice, will guide us through the Indonesian context, drawing from his work at the intersection of freedom of expression, human rights, and environmental justice. So we're really grateful for your time, expertise, and generosity in sharing your expertise across jurisdictions and legal traditions. Your insights will guide us as we unpack the nuanced challenges and opportunities in combating SLAPPs in Europe and especially in France. First, a few logistical considerations before we begin. Please use, so to the attendees, please use the Q&A tool for questions to the speakers throughout the event. The chat will remain open for networking and general exchanges. At the end of the speakers' presentations, we will have a dedicated Q&A session where your questions will be addressed by the speakers and our moderator. Without further ado, I'm pleased to introduce you and give the floor to Fiona Houdin, legal advisor at the Commission nationale consultative des droits de l'homme, the French National Human Rights Institution, for a keynote speech on the French context and the state of play regarding SLAPPs. Fiona, we're really grateful to have you. We kindly invite all our speakers to draw links between your national experience and the elements raised by Fiona as a starting point for comparative reflection. Fiona, please, the floor is yours.
Thank you. Thank you very much. Thank you to GROW for the invitation. Thank you to the other panelists also for the insights they're going to give today. I would like to start with an apology. Unfortunately, I won't be able to stay for the the rest of the exchanges. I have to say I'm currently in Spain, where there's a power outage at the moment. So I hope my connection will stay with me for this intervention. But I will be really pleased to learn more about what is going to be said in the next phases of the event through the notes of the GROW team. So about my keynote today, that are entitled Combating SLAPPs in France, a Challenge to Overcome. It's a real challenge in France, as we do not have currently legislation specifically against SLAPPs. But I will tell more about this in a second. I would like to start first my presentation by a presentation of the institution I work in, the CNCDH. So the CNCDH is the French National Human Rights Institution. It has three core missions. The first one is to advise public authorities to enlighten public decision on human rights and international humanitarian law matters with opinion and declaration, which give recommendations to public authorities. Then a second mission is to control that the state complies with its international obligations, for instance, linked with the United Nations Committee. And the third mission is about human rights education. So, for instance, production of tools and content that can be used by teachers in school. So this is a brief presentation of the institution, which is composed of 64 members, half representing civil society. So, for instance, NGOs, trade unions, and half experts. And the CNCDH produced, as I mentioned, opinions. And in February 2025, so this year, we adopted an opinion on the fight against SLAPPs, which was in the context of the EU directive of April 11th, 2024, adopted at the level of the European Union. And that France has to transpose in French law before May 2026. So the CNCDH adopted this advisory opinion to raise awareness on the importance to prevent these proceedings to transform public interest issues in private disputes, as it would be a disproportionate breach of the freedom of speech and the public debate in general. This opinion deals with the judiciary aspect, which might lead to financial difficulties or harm of the credibility and reputation of actors such as NGOs. And the CNCDH is currently working on another opinion on the reduction of civic space, which will deal with freedom of association and the problems association can have to finance themselves. So now to talk more about the subject that is the object of today's webinar, and to talk more about what the CNCDH recommended in its opinion. The first important part was the definition of what is a SLAPP, because there's no definition in French law at the moment. So the definition of the European directive adopted in 2024 was that abusive court proceedings against public participation are court proceedings which are not brought to genuinely assert or exercise a right, but have as a main purpose the prevention, restriction, or penalization of public participation, frequently exploiting an imbalance of power between the parties and which pursue unfounded claims. This was already a really rich definition of what a SLAPP can be. But at the CNCDH, for our opinion, we decided that some little things needed to be added. And we suggested to also include the intent to harass or intimidate the target, because we really, in the auditions we made, this idea really was really highlighted by several victims of SLAPPs in France. So this seemed really important. And then there's some indicators that are included in the European directive to help the judges, but also lawyers, to identify a SLAPP when they encounter one. So there are four main indicators at the European level: the disproportionate, excessive, or unreasonable nature of the claim, including the excessive dispute value, then the existence of multiple proceedings initiated by the claimant or associated parties, intimidation, harassment, or threats on the part of the claimant or the claimant's representatives before or during the proceedings, and also the use in bad faith of procedural tactics, such as delaying proceedings, fraudulent or abusive forum shopping, or the discontinuation of cases at a later stage of the proceedings in bad faith. So these are really important indicators. But once again, the CNCDH thought that the judges, the lawyers would need more indicators because SLAPP can take a lot of forms. And it was important to have indicators that could cover all these situations. So the indicators we would like to add to the French framework are also in accordance with the recommendation of the Council of Europe that was adopted in April 2024, just a few days before the European directive. And includes the attempt of exploitation by the claimant of a power imbalance, its financial advantage, or its political social influence to put pressure on the defendant. It also includes arguments of the claimant partially or totally without grounds, the abuse of law or procedure by the court proceedings brought by the claimant, the action of going after physical persons rather than organizations that are responsible for the disputed act. And finally, when court proceedings are accompanied by public relations offense, aiming to harass, intimidate, or discredit persons participating to the public debate, or to divert the attention to the real issue at stake. For us, it was really important to give these indicators because it would help also the victims to identify when it's not a normal proceeding, but it can be identified as a SLAPP, and then protection associated with SLAPPs can be asked. So that's about the definition and the indicators that the CNCDH recommends to be included in French law. And then we did kind of a study, an overview of the different SLAPPs we have in France, and the more common grounds, for instance, that are used by claimants. And we saw that before criminal courts, it could be defamation, slander, forgery, and use of forged documents, violation of the secrecy of judicial inquiries, apology of terrorism. So very diverse grounds, and it's the same before civil and commercial courts with disparagement, violation of trade secrets, monetary and financial code offenses. So that's a quick overview, but which shows that there's not one ground that is used. It can be before different courts also. And that's important also to know how to spot SLAPP, that it's not only defamation, for instance, it can be various grounds. And then about the claimant profiles, for legal persons, it can be small, medium enterprises, but also multinational companies. It can be natural persons, of course, public personalities, politicians, both at a local and national level, businessmen, businesswomen. So same, there's no typical claimant profile, although we tend to see that the power of the person that could be the power in the media or the financial power is an important aspect of the profile. And finally, for the victims' profiles, there are also very diverse. It can be human rights defenders, journalists and media, academics, trade unionists, or victims of gender-based and sexual violence. And this was also interesting for us to see that a lot of persons can be a victim of SLAPPs just because they participate in the public debate. It's not just the typical profile that we have a lot in the media about this environmental human rights defender against multinational company. It goes way, way beyond that. So that was the overview that we had when we started to work on SLAPP. And then maybe I can give you some case studies to better understand what we have, what we face in France when it comes to SLAPP. And also, because we have this case study in mind when we made our recommendation that I will talk about in a minute. So about this case study, the first one is a case of Sherpa versus Vinci. So Sherpa is the French NGO defending human rights and environment from economic actors through strategic litigation, advocacy, legal research, and capacity building activities. And the origin of the SLAPPs in this case were a complaint brought by Sherpa against a French company, a really big company, Vinci Construction, and its Qatari subsidiary. And the grounds of the complaint were first forced labor and servitude, and the disputed acts were allegedly committed against migrants employed on construction sites that the Qatari government handed to the Vinci company in the context of the organization of the 2022 Football World Cup. So that's about the context. And after this complaint was brought by Sherpa, then some people were pursued by Vinci, Sherpa, and two of its employees, so the president and the director of the NGO. And here we see one of the indicators that we recommended to be included. It's the fact that it was not only the NGO that was in the summon of Vinci, it was also physical persons, the president, the director. And that is to put pressure on physical person and not only the organization in itself. So that for us is an indicator that it is a SLAPP. And then about the grounds used, there were two grounds, defamation and the violation of the right to be presumed innocent. And two types also of proceedings, an emergency interim proceeding and a main proceeding. And that also sticks with the indicator that I gave you a few slides ago about the fact that there are multiple proceedings with also different grounds that are used by the company to try to intimidate, to amplify the costs that the NGO has to face because they have to defend themselves on various proceedings. And also the claims are interesting in this case. There were 350,000 euros in damages claimed by the company, 10,000 euros for publication fees by newspaper, and 10,000 euros fine also, which was reduced then to one symbolic euro. So this shows that this is to put pressure on the company, especially the 10,000 euros for publication fees by newspaper. This is a huge amount for a smaller NGO. But fortunately, the judge made a decision to dismiss the emergency interim and main proceedings on violation of the right to be presumed innocent, because the terms used by the NGO tended to demonstrate the merits of the complaint, the initial complaints, and highlighted that they had evidence in their possession. And so the judge decided that Sherpa was in its right to defend and express its argument, considering the attacks, meaning the proceeding brought by Vinci against Sherpa. But the other proceeding is still ongoing, the one on defamation, which means there are still costs that Sherpa has to cover in this case. And now quickly, a second case study, this time Greenpeace versus Total. I did the overview before also to show, because my two case studies are about NGOs with an environmental link against a big company, but that's not all that we have in France, of course. But this one was really interesting because the origin of the SLAPP is the publication of a report by Greenpeace France, which evaluates the real greenhouse gas emission of Total Energies. And the person pursued was Greenpeace France, so only the NGO, but the ground used is why I chose this example, because the ground used was dissemination of misleading information to stock markets. And that really shows the creativity of the company to use a ground that we would not at first think would be used for a SLAPP. It's far from the freedom of expression typical example. And that's also what makes it really complicated for victims to defend, because then it goes before commercial courts. And in France, commercial courts are not led by trained professional judges. It's the judges in these courts, in these commercial courts, they are director of companies themselves, for instance. So they're not used to issues of freedom of speech, for instance, because it's not what they do. Usually, they deal with problems that companies have with other companies, and that can be also something really interesting for the companies that want to prevent some NGOs to participate in the public debate denouncing some of their practices, because they have in the court people that will think more like them and not like judges that are used to dealing with the protection of the press, for instance. And so the claim used. The claim of Total Energy was to remove the disputed report and all related publication under a 2,000 euros per day penalty, €1 of symbolic damages, and 50,000 euros of legal fees. So now we see that it's not the damages that is damaging. In fact, it's more the legal fees, because it's a really huge amount, and also the fact that the report is published. There's also a really high penalty. But in this case, also the judges they decide the nullity of the summons of Total Energy for lack of precision, but they did not convict Total Energy for abusive proceeding. And they convicted the company to pay 15,000 euros of legal fees. So these were some cases that were interesting because it really illustrates the diversity of SLAPPs we have in France, and so the necessity to adapt the legal framework to tackle all these different proceedings, and not only, for instance, defamation. And about now the existing tools that we have and the main recommendations we made at the CNCDH, and also to for the other panelists also maybe to have a better understanding of all that we lack at the moment in French legislation. We have civil fines for abusive or dilatory proceedings. For instance, we have in the French Code of Civil Procedure a civil fine of 10,000 euros. But the problem is it's a very restrictive case law of the highest court in France, the Cour de Cassation, which requires judges to have a reinforced motivation on the abuse and the dilatory characteristic of the proceedings, and it really limits the reach of this provision. And for instance, in the case I mentioned before, in the Greenpeace versus Total Energy case, Greenpeace sustained that the summon of Total Energy had for only goal to restrict the public debate by circumventing the protection of the 1881 law on the freedom of speech, and that it constituted an attempt to intimidate Greenpeace and bypassing the imperative provision on freedom of speech. But the tribunal recalled that the right to bring a case before justice degenerates into an abuse only in case of mischief, bad faith, or gross misdemeanor that is equivalent to a willful misrepresentation. And so judges considered in this case that Greenpeace did not define sufficiently the misdemeanor of the company in its right to take legal action. So we see it's quite restrictive, and the amount of the fine is only 10,000 euros. And for a big multinational company, it can also be it can't really be dissuasive. Then we have in the French Code of Criminal Procedure several articles that can also lead to the imposition of a fine, but it's limited because, for instance, in case of late withdrawal or an exception of procedure, such as the nullity of the summon, it won't be applicable. And then we have a final provision in the French Commercial Code. And in this case, every natural or legal person which acts in a dilatory or abusive manner on the grounds of the chapter relative to the protection of trade secrets might be convicted to pay a civil fine, which amount can be up of 20% of the damages sought. And if there's no damages claimed, then the amount of the civil fine cannot exceed 60,000 euros. And in this article, it's the first time that we have the mention of the French word for SLAPP, procédure bâillon. So this is a new article that was added to the commercial code a few years ago, and we see there that the fine, the amount of the fine, is more dissuasive than in the two previous examples. So that for us could be the model for the French legislation against SLAPP, because it's more dissuasive, and it also takes into account the fact that sometimes damages are not claimed, but if the damages are really important, then the fine can be of important amount. So that about the fines. And then there's also, of course, provisions on damages themselves. So we have the general ground for civil liability in French law is in the civil code, and some damages can be granted. There is a demonstration of a misdemeanor, a prejudice, and a causal link between the two. And the victim of a SLAPP can seek compensation as long as they demonstrate the existence of an abusive proceeding, which means there's no legal basis, there's a malicious intent, an intent to harm, an obvious bad faith, or the multiplication of proceedings initiated. But that has to be asked separately from the main proceeding. Then the provision in the Code of Criminal Procedure, an article, Article 91, that provides that after a case has been opened by an instruction judge on the basis of a complaint that is filed by a plaintiff, and there's then a dismissed case by the judge, then the indictee and all the persons that were mentioned in the complaint can apply for damages from the plaintiff. And there's another provision in the Code of Criminal Procedure. I'm sorry, that's a lot of provisions, but I think it's really important to understand what we have, because that's kind of all we have, and that it is not for now sufficient to truly combat SLAPPs. And this article provides that a discharged person can apply for damages against a plaintiff for abuse of complaint when the proceeding was initiated by direct summons. Then in the case law, the Cour de Cassation made it possible to obtain also damages when a complaint was filed by the plaintiff before an instruction judge. But it means that no compensation can be granted in case of late dismissal, nullity of the procedure, or inadmissibility. And that's a problem because it's also quite restrictive, and it can lead the person that wants to bring a SLAPP procedure to do it, and then just to withdraw their complaint at a later stage. But the harm will have happened, and a lot of costs will have to be covered by the victim of the SLAPP. And it's also a problem because these provisions are not applicable in media or press law. So, for instance, for defamation, it won't work because when there's a characterization of the offense of defamation, then it's not possible to go to these provisions. Even though there's a good faith, even though it was to participate in the a general public interest debate, then it won't be applicable. So with this, we thought we had some recommendations to make to the public authorities to truly put in place a framework and also train professionals in France so that we can combat SLAPPs in a more efficient way. So now about the main recommendations that we made in our opinion this year. It was first to define and broaden the legal framework, so to introduce a definition of SLAPP, and also to allow this framework to protect victims in all jurisdictions, and not only before civil jurisdiction, for instance. So we recommend the adoption of a precise definition of SLAPP proceeding, and also a framework that includes purely domestic cases, because the problem with the EU directive that was mentioned at the beginning is it only applies to trans-border litigation and not domestic cases. And in France, in the numbers we have at the moment, it's like less than 10% of the cases that we have. So it's really important that domestic cases are included. And same for proceedings brought before the criminal courts. The EU directive do not apply to criminal proceedings, but in France, we have a lot of grounds that are used, and I showed you the list a few minutes ago, for instance, defamation, that are brought before criminal courts. So it's important that all these cases are included in French law. Then the second list of recommendations is to put in place an effective protection system. So we recommend the creation of an advance payment mechanism that can be granted to defendants in SLAPP proceedings as soon as the proceeding is initiated. And this is based on an existing model we have for the protection of whistleblowers. And it covers both the cost of legal representation and also the damages that may be awarded if the SLAPP proceeding is found to have been initiated. So we think this could be really dissuasive if it's not only the cost of the legal representation, but also the damages that could be granted at the end. Then we recommend to amend the codes of civil and criminal procedure to provide that the judge will be obliged to charge the plaintiff when we have a recognition of SLAPP with all the legal costs incurred by the defendant, if they're not excessive, of course, but that can also be dissuasive if we know that before we brought a SLAPP, if we know that the costs, the legal costs, will have to be covered. And then we recommend to encourage also the involvement of civil society in support of a defendant in SLAPP proceedings by extending, for instance, the practice of amicus curiae to all courts, because that can be really useful. There are NGOs that know really well how SLAPP work and that can identify also the SLAPP more easily. So that would be interesting if they can give some insights to the court. We also recommend to modify the amount of civil fine, and for this civil fines to reach 20% of the damages claimed, or 60,000 euros, if damages are not claimed, based on the provision that is currently in the commercial code. And we also recommend to introduce an early dismissal mechanism before civil, commercial, and criminal court. This is a provision of the EU directive, the early dismissal, but we would like that this mechanism also covers criminal courts and not only civil courts. And finally, the last set of recommendation is about the prevention and monitoring of the phenomenon. This is about the training courses for judges and lawyers that have to cover all the indicators that we identified, and also the importance of a rapid dismissal and financial and procedural guarantees for the defendants, and also taking into account the different impacts that these proceedings may have on victims, because, for instance, for victims of gender-based violence, the fact that they are the target of a SLAPP proceeding, this can be really a re-victimization that has to be taken into account in the assessment of the damages that have to be granted also. And also, we recommend to draw the attention of companies that the measures to prevent SLAPP proceedings are integral part of their duty of diligence obligation, with regard to human rights obligation that they have as companies, because they need to take this into account, not to have negative impacts on this rights, for instance, the freedom of speech right of the defendants. And finally, we recommend to create a statistical code that will allow courts to record the number of SLAPP that we have in France, because for now, we really rely on the work of NGOs, and they do a really, really good work, but they're not courts. So they do not know all the proceedings that could be identified as SLAPP at the moment. And it's really important to adapt the public policy to know the numbers, to have an overview of what numbers we're talking about, what kind of also of grounds are used, and to follow the evolution of the phenomenon. It's really, really important to have numbers. So that's about sum up the recommendation, but our opinion is 20 pages long. For now, it's only in French, but we hope that we can translate it in English in the coming months. But I will really invite you, if you're interested in the subject and what we advise the public authority to do, to read the full opinion. Maybe some conclusive words from our president, that public debate is one of the pillars of democracy, and the protection of this public debate that can guarantee that any individual or legal entity can express the views and participate in sharing information of public interest. And it's a real a major responsibility of the state. The fight against SLAPP is essential if we want our judicial system to be used to protect human rights and not to harm it. I really personally think that this webinar and the comparative law exchanges that we're gonna have today is a very important tool, and a step in the right direction to help the French public authorities to design a legal framework in France that will be the more efficient to combat SLAPPs, and to use our resources, our judicial resources in a good way. So I would like to thank you again for your attention, and I'm really looking forward to the exchanges that are about to come. I can stay about maybe 10 to 15 minutes, and then unfortunately I will have to leave. But again, I will keep in touch with the growth team to know all the recommendations and that you can formulate today as a panelist, so I can also bring that in our exchanges with the French government on the future law on the matter.
Thank you. Okay, go ahead, Susanna.
Sorry, thank you so much, Fiona, for this incredibly interesting presentation. We can only hope that the French legislator will include all those remarks in its works. I see we have one question, and although we planned to do the Q&A session at the end of the event, as you are not able to stay with us, I thought it might be interesting for you to answer this question. It's whether the integration of the indicators suggested by the the Commission, have altered the outcome of the Shepra and Vinci cases and the Greenpeace versus Total cases.
So if I understand correctly, if this had an influence on the outcome of the case, I'm not sure it has had an influence yet, but it's true that Sherpa can use our opinion to support the claim that they're in the right and that the defamation the defamation proceeding is a SLAPP. Sherpa was one of the person we auditioned for this opinion. So we're in contact, and of course, this can be a help for current cases going on, because it happens that the CNCDH opinions are used by the judges, and they cite it in their decision. So hopefully it will help, but for now we don't know if it has had an impact.
Okay, thank you so much. And thank you again for the presentation. And now I will pass the floor to James and Turk and ask him to tell us a bit about SLAPP legislation in Canada.
Thank you very much. I'm delighted to have been invited to be with you today, and I found the past presentation very interesting. Several years ago, in 2023, we did a major study of all the anti-SLAPP legislation, every jurisdiction in the world that had it. Now, the fact of the matter is that meant it was in 33 US states, 3 Canadian provinces, and 1 country, Australia. And just as a background, before I get into the Canadian experience, I want to tell you the criteria broadly that we use to assess the effectiveness of potential effectiveness of anti-SLAPP laws. And I'll come back to that at the end of my presentation and give you a link to where you can get the document that provides this in considerable detail. We looked at a number of criteria. The first was the scope of the law. And that is, some statutes are very broad in scope, applying to all proceedings arising out of expression made as a matter of public interest or public concern. Other statutes have a narrower scope, for example, only applying to expression before a government body or to expression on a specific issue, such as land use disputes. And still others appear very broad in scope, but have important exclusions that limit their effectiveness. For example, the law in Australia excludes, under its anti-SLAPP protection, any defamation suits. So it doesn't protect against a SLAPP suit that's defamation. So scope of the law was the first. The second is the burden of proof. The strongest statutes place a minimum burden of proof in seeking to have this lawsuit dismissed on the defendant of the lawsuit. In other words, the strongest statutes require the defendant only to show that the matter before the court is a matter of public interest. The third criterion is that the burden of proof, after the defendant shows it's a matter of public interest successfully, the burden of proof shifts to the plaintiff in the SLAPP suit, who has to, the strongest statutes, put that heavy burden of proof on the plaintiff to establish that their action has merit, that the defendant had no defense, and that the public interest weighs in favor of allowing the original action that unless the, I'm sorry, I'm not saying that well, unless the public interest is more, it's more important, the public feels, for the original action to go forward. So a lot of the statutes don't shift any burden from the defendant onto the plaintiff. In other words, the burden is entirely on the defendant to show the court the matter is not, should not go forward. The fourth criterion is whether the proceedings are stayed. The strongest anti-SLAPP suits do not allow any proceedings between the parties to the SLAPP suit, including discovery or any pending hearings or motions, to continue until the motion to dismiss the SLAPP suit is disposed of. Most statutes, however, only limit pause discovery, and some statutes don't impose any stay on the proceedings. So when the defendant in the SLAPP suit is trying to have the matter dismissed as a SLAPP, the proceedings on the original motion on the original action can go forward. The fifth is whether a prevailing defendant is presumptively entitled to costs. The strongest statutes state that the court shall award costs and the attorney fees to the defendant if the defendant is successful in having the motion dismissed, but will not presumptively award costs if the plaintiff is successful. And some require additional showings by the successful defendant to receive costs, and some acts don't even provide any provision for the defendant who's successful to receive costs. Sixth, we looked at whether there's a procedure for scheduling expedited hearings of anti-SLAPP motions to have the SLAPP suit dismissed. Some jurisdictions have a requirement that the hearing be heard within a certain number of days to minimize the legal costs to the defendant in the original suit. The seventh criterion was whether there's a right of appeal on an expedited basis. That is, if the defendant in the original lawsuit is not successful in having a motion to have the matter dismissed, that they have a right to appeal it, and that right, the appeal has to be heard in an expedited manner. The eighth provision of what we thought were strong SLAPP suits, anti-SLAPP suits rather, was whether the act contains a damages provision. That is, that allows the court to award damages in addition to costs when it considers the plaintiff brought the action in bad faith. And then lastly, whether the legislation contains a statutory interpretation clause. So some of the stronger statutes contain a provision stating that the anti-SLAPP law is to be read broadly and liberally. So that's the framework in which we looked at anti-SLAPP legislation. I'll come back to that, but I give you that background because we have had some experience with anti-SLAPP laws in Canada. Now, how do it's showing my, excuse me, I just have a technical question. It's showing my PowerPoint on the screen. Now, do I share my screen and control the PowerPoint myself?
So normally you already have the right to control it. So at the bottom left corner, you should have like some arrows that you should be able to use to move on to the next.
Okay, in the bottom, oh, I see, okay. There, okay.
Great, super.
So our first experience with anti-SLAPP legislation was in the province of British Columbia, which is on the west coast of Canada and directly north of 3 states in the United States that were amongst the earliest, had the earliest anti-SLAPP laws. And I should say that in every case where there's a successful anti-SLAPP law adopted in Canada, there has been the same pattern that led to that happening. And that pattern was that it involved a high-profile public dispute between land development corporations and municipalities who were being sued by the Land Development Corporation, individuals who were being sued by it, environmental groups that were being sued by it, or municipal councilors who were being sued by it. So in every case, we've only been successful in getting anti-SLAPP legislation when the issue of SLAPPs was a public issue. And it was in every case in our country as a result of people, large corporations or land development corporations wanting to use land in certain ways, being opposed by environmental groups or being opposed by municipalities, and the corporations suing them for large amounts of money in such a flagrant manner that it became a matter of public interest. And now, in every case, that created the conditions for the successful adoption of anti-SLAPP legislation. Before, we had talked about it, but we weren't able to move governments to actually introduce the legislation in the absence of those conditions. So that happened first in British Columbia in 2001. And I'm not going to go into the details of theirs because it was legislation that was brought in 2 months before a provincial election. And the party that brought it in, the Social Democratic Party that brought it in, lost the election, and the new government immediately repealed it. So that only lasted 4 months. The next province that had it is the province of Quebec in the eastern part of Canada. And the experience in Quebec, the anti-SLAPP legislation in Quebec, in some ways isn't really anti-SLAPP legislation. That is, the law did not address SLAPPs specifically, and it rather dealt with a larger notion of improper procedures in court. It didn't change any existing laws, and it didn't create any new obligations, but rather it changed the rules of legal proceedings, leading to more robust procedural provisions dealing with abusive lawsuits and proceedings. So it dealt with a broad range of abusive behavior in court, and by changing proceedings that the courts were to be guided by. So it has the effect of providing some protection against SLAPPs, but it technically is not a lawsuit that was brought in as an anti-SLAPP lawsuit. The third and most important one that I am going to talk about a bit was the protection of public participation lawsuit law that was brought in Ontario in 2015. As in the other cases I mentioned, there had been a high-profile dispute between land developers in Ontario and municipalities, municipal councillors, environmental groups, and certain individuals. And it was so intense that the Attorney General of Ontario appointed a committee made up of the Dean of Law at the University of Toronto and two very well-recognized experts in anti-SLAPP law to form a committee to bring in recommendations to the Attorney General as to whether Ontario should have an anti-SLAPP law and what its nature should be. They did that within about a year, and over the next 3 years, there was broad consultation over that, and it resulted in the introduction of the law I'm about to describe to you, which by our analysis is the strongest and most protective anti-SLAPP law in the world. It's entitled the Protection of Public Participation Act. And interestingly, every province that's introduced anti-SLAPP legislation has given, except Quebec, which did it a different way, has given the same title to its law. The act applies very broadly. It applies to any legal proceeding arising out of expression made on a matter of public interest or public concern. So it can apply to any kind of legal action as long as that legal action arose out of expression. The law also defines expression very broadly, which is the definition you see in front of you. Expression means any communication, regardless of whether it is made verbally or non-verbally, whether it is made publicly or privately, and whether or not it is directed at a person or entity. So it's a very broad definition of expression and a very broad definition of any legal action relating to expression on a matter of public interest. Now, the act, under the act, if one of you was sued by a corporation, a defamation suit or another kind of lawsuit over your expression that they wanted to silence you on, you could bring forward a motion to a motions judge in Ontario to dismiss the lawsuit at the earliest stage of the litigation process. The motion under the anti-SLAPP law in Ontario has to be heard within 60 days. The defendant, that is you being sued by the corporation, the defendant must satisfy the judge that the matter between the two parties is a matter of public interest. So that's a very low bar to get over. So that's the first step. If the defendant satisfies the judge that the dispute is a matter of public interest, then the onus shifts to the plaintiff, the corporation that brought the lawsuit, which must show three things. It must show that the lawsuit that the plaintiff has brought forward has substantial merit, and that the defendant, that is you, has no valid defense, and that the public interest in letting the case proceed is greater than the public interest than it is in protecting the defendant's freedom of expression. So those three things. And if the plaintiff cannot do all three of those, then the motion is dismissed. So it's a heavy burden on the body that brought the SLAPP suit. And if it's not unable to satisfy the judge of those three factors, then the motion is granted and the original lawsuit is dismissed, is ended. Now, if it is dismissed under the Ontario law, the defendant in the original lawsuit, that is you, is eligible for full recovery of their legal costs. In Canada, when you get costs awarded in your favor, it's usually 40 to 60% of your actual costs. This would be an exception. You get back 100% of your costs. If the judge feels the lawsuit was brought in bad faith, the original lawsuit, or for improper purposes, the judge may also award the defendant additional damages. Further protections for the defendant is once the defendant goes to court to have a motion to have the original lawsuit dismissed, the plaintiff in the original lawsuit is prohibited from amending their proceedings in the original lawsuit to prevent or avoid it being dismissed, or if the proceeding is dismissed, in order to continue the proceeding. In other words, everything is frozen. The plaintiff in the original case can take no action that extends the matter or in any way changes it. And if the defendant is not successful in getting the motion dismissed, they are not subject to costs. So if I'm a corporation, I sue you, you go to the motion judge to have it dismissed, you're not successful, you are not awarded costs against you. You're not subjected to costs, having to pay costs. And as well, if the defendant is unsuccessful in getting the motion, they have a right to an immediate appeal to be heard as soon as practicable. So in the evaluation we did, that was the strongest anti-SLAPP protection of any jurisdiction that currently had an anti-SLAPP law as of 2023. In 2018, the province of British Columbia, at our urging and several others, essentially adopted the Ontario legislation, changed the wording so that it applied to the relevant changes that were necessary in British Columbia law. And within 8 months, which is record time for legislation being passed in Canada, in any Canadian jurisdiction, passed the law, and it passed unanimously in probably the most divisive political province in the country. So British Columbia has the same law as Ontario currently, and our center is working with civil society groups in each province to get other provinces to do so. The province of Manitoba in the middle of the country has introduced, again, essentially the same legislation in Ontario, and we're about to do that in a 5th province as well. Now, I made reference to our review of anti-SLAPP legislation in all the jurisdictions in the world where it existed in 2023, and that shows you the rankings. And at the bottom of the screen is the link to the report that's on our website, so you can look at it, which goes into more details of the criteria by which we evaluated and what were the strengths and weaknesses of the legislation in each jurisdiction. So I'll stop there and be happy to answer questions when we get to the question and answer period.
Thank you so much. It was extremely interesting. I will have some questions myself for sure. And now I will pass the floor to Lady Nancy Zulugao Jaramillo to tell us a bit about how the situation is looking in Mexico.
Thank you very much, Susana, and thank you so much for the invitation to be here today. It's a pleasure to be able to share more about the work we do at the Resource Center in terms of SLAPPs. So I will just go quickly a bit about our methodology, what we do in SLAPPs, and then I will focus a bit more on Mexico and Latin America generally. So the first thing I wanted to mention is that for those who are not familiar with the Resource Center, we are an international human rights organization that works on advancing human rights in business. So we monitored like good practices by business, but also we monitored situations where companies have been linked to irresponsible behavior. So as part of our work, we have been monitoring the situation of human rights defenders around the world who have been raising awareness about businesses in general. And we have like a global database that tracks attacks against defenders. And I'm mentioning this because so far we have identified more than 6,300 attacks against defenders, including killings, threats, violence, but also different forms of judicial harassment, including strategy lawsuit against public participation. So we have a database on our website with like many different cases, but we also have a dedicated database on SLAPPs that just include more than 200 cases around the world with examples of SLAPPs. And I also wanted to just explain what we include in our methodology, because as Fiona highlighted at the beginning, SLAPPs, the definition of SLAPPs is not clear in many jurisdictions, and also is not a clear global definition of SLAPP. So this is an important thing to have in mind. So we decided to, or at least we cover in our database and in our work on SLAPPs, only lawsuits that are initiated by private actors, by companies or persons linked to companies against people or against defenders who are raising awareness about business activities. And I'm saying this because we recognize that there are other groups and other organizations in different parts of the world that go beyond lawsuits and include other legal tactics as part of this global phenomenon of SLAPPs. So for the purpose of my presentation, but also for the purpose of the Resource Center work, we only include lawsuits, but we recognize that others have a broader definition. So now I just wanted to quickly share an overview about our data, what we see, and then I will focus more on Latin America and Mexico. So since January 2015 to December 2024, we have identified over 530 lawsuits that bear the hallmarks of SLAPP in different parts of the world, but we also see that the United States, Honduras, Peru, Thailand, Mexico, Cambodia are at the top list of these 59 countries, but we have identified many cases in Africa and also in other countries in Asia, and I'm glad that we will hear more about Indonesia today. So according to our data, unfortunately, Latin America and Asia and the Pacific are the regions with the highest number of SLAPPs. And this is also really interesting because when we talk about SLAPPs, we at the Resource Center, and also based on my research, we see differences between SLAPPs happening in the global north, if you want to make this distinction, and SLAPPs happening in the global south. And I will share like a couple of insights towards the end of my presentation. Also, something really important to highlight is that many of the SLAPPs that we have identified in our work are related to like 3 specific sectors. Mining, agribusiness, and logging and lumber are the sectors that are commonly using SLAPPs, but also we see that many of the people that are affected are working on environment or land rights or sustainable development, like these kind of issues that are currently really important. So now in terms of Latin America, I just wanted to like share this like table with some numbers. So as I mentioned, Asia and the Pacific and Latin America in general are the 2 regions with the number of cases, like the highest number of cases. And if we focus only in Latin America, Honduras, Peru, Mexico, Guatemala, and Ecuador are like the countries where we have been able to identify most of the cases. And out of these 531 cases, 191 are happening in Latin America. And also one of the biggest difference that we see in cases happening in the global north versus cases happening in the global south is that many of them in the global south, and especially in Latin America, involve criminal charges. And this is like really particular to our region and also to other regions because companies actually have the right to just go to use the criminal law to intimidate and harass offenders, and we know that in other jurisdictions this is like different, but in Latin America, unfortunately, the use of the criminal law is like really common, and many of them have this form of or the intention to intimidate and harass the offender. And this is also really important because when we think about measures or like legal measures or other kind of measures to prevent, but also to protect people potentially like facing SLAPPs, like the tactics should be a little bit different because this can involve, for example, just law reforms, for example, related to defamation laws that still have this criminal angle and so on. So now, in Mexico in particular, and I won't go to this specific slide, I can just explain that later. But in Mexico in particular, as you probably saw from the previous slide, we have identified around 30 cases that were the hallmarks of SLAPPs, but we know that the universe there is bigger since we only cover cases that we are able to confirm by public sources. So we don't actually like review legal documents, or we usually don't like are able to access like court documents or anything like that. We just analyze public sources, many of them coming from NGOs, coming from like different like media outlets, but also coming from reports by international organizations, regional organizations, and others. So we know that this number that I just give you is just an estimate, and the universe in countries such as like Mexico and in others, the scale is bigger. But at least what we have been able to identify with this number that we have is that the geothermal energy, property development, many of them related to the construction of big hotels, like big resorts and these kind of things, and also logging and lumber and the agriculture and livestock sectors are linked with most of the cases. And many of the people and the defenders who have been targeted by this malicious tactic have been working for clean, healthy, and sustainable environment. Many of them like environmental concern groups, but also community members or community leaders that are just trying to protect their territories from like irresponsible business practices. And this is really important because, we see that this is something quite similar in other countries in Latin America, where people are just standing up, like defending territories, defending the environment in general. And it's also like really important in terms of the climate crisis. And also when we think about other types of attacks beyond SLAPPs, we see that also environmental defenders are being like killed in many jurisdictions, are being threatened by different tactics. So this is something that we should have in mind, that at least this specific group of people defending territories and defending the environment, not only in Mexico, but in many jurisdictions, are being targeted by the use of SLAPPs. Also, something to mention is criminal charges are the most common in Mexico, many of them related to damages, defamation, instigation in different levels. And this is quite scary because when we talk about this kind of criminal arguments, people can face like lengthy prison sentences. So we're talking about people like that can face 10 years in prison, 20 years in prison, just because someone decided to initiate a criminal complaint against them. So this is something really important to have in mind. Also, like around 33% of the SLAPPs that we identify in Mexico were against women. So when we talk about the intersectionality between different things, including like LGBT rights, women, or indigenous people, like the consequences of facing a SLAPP like are really important. And this is also something that we should have in mind in terms of providing support, providing reparations, or just thinking about preventing the use of SLAPPs. As in many other countries and in many other jurisdictions, we also see that SLAPPs are initiated like immediately, like defenders raise awareness about a specific economic project, or they participate in any public event, they release a report, or like this kind of like things that just are like trying to disseminate information and to raise awareness about specific issues. And something very important to have in mind, and I just like wanted to echo what Fiona said in her presentation, is that in Latin America and in many other jurisdictions, SLAPPs are actually against individuals and not only against organizations. Actually, we see that individuals are more targeted by SLAPPs. We also have like documented SLAPPs against like big organizations. But unfortunately in Mexico, and this is a really important thing to mention, is that many of the SLAPPs are against specific individuals, specific community leaders, and that are just trying to oppose to different economic activities in their territories. And I know that I'm running out of time, but I just wanted to tackle a little bit about what challenges and progress we see in Mexico, that these are quite similar in other Latin American countries. So first, in Mexico, criminal defamation law still persists in some states. And this is really important when we talk about like measures to prevent the use of SLAPPs. Also in Mexico, there is not any anti-SLAPP mechanism or any anti-SLAPP legislation. And this is like similar in many, like I would say that in most Latin American countries, that unfortunately we don't have like this kind of anti-SLAPP laws in our countries. There are like some initiatives in a couple of jurisdictions, but we don't have like any like big example or rule example about this kind of legislation. So usually the legal like tools that people have in Latin America, but also in Mexico, is the Constitution and maybe other laws that are like protecting like freedom of expression generally, but not necessarily that can help people with defending themselves when they are actually facing SLAPPs. Also, something really important to have in mind is that in Mexico particularly, but also in other countries in Latin America, when we talk about judicial systems or when we talk about SLAPPs, we also need to have into consideration this collusion between state authorities, companies, and organized crime. And also people facing SLAPPs, they are not only facing them, they might be also facing other type of threats. They are usually like being intimidated by in social media. They are usually like many of them like can face death threat and this kind of like risk. So the complexity of the context of SLAPPs in Latin America also is related to the complex social, political, and economic context that we face in our territories and our region. So this is why when we talk about judicial system, we also see that the corporate capture, corruption should be into consideration to think about potential measures to tackle this issue in Mexico and other jurisdictions. Some positive things that I wanted to mention is that there are like a couple of important developments in the Inter-American system of human rights. This is our regional system that protects human rights in our region. There are like two important decisions by the Inter-American Court of Human Rights, one related to Chile, another with Ecuador, but also there have been like two public hearings before the Inter-American Commission of Human Rights that have like highlighted the impact of SLAPPs in different countries, including Mexico. And also we are expecting a potential report by the Inter-American Commission of Human Rights by the Special Rapporteur on Freedom of Expression that will focus on SLAPPs. So we hope that with this report that will come up probably later this year or next year, with this development by the Inter-American Court in these specific cases, countries will start developing like more anti-SLAPP measures or other measures to protect defenders. And also something important, at least in the context of Mexico, is that there is a mechanism to protect human rights defenders and journalists, like mechanism that was like put in place by unfortunately, I mean, there are so many and like how effective it has been in the country to protect defenders and also specifically in terms of SLAPPs. And just finally, some of the challenges in documenting SLAPPs in Mexico that I would say is quite similar in other jurisdictions is also related to like the difficulty in terms of differentiating cases that are coming from the states and cases that are coming only from private institutions or from private parties, because as I mentioned, there is a lot of collusion, a lot of corruption, and so on. So it's like really important to make this distinction between like judicial harassment more broadly, criminalization, and SLAPPs. And this is something that we have been like trying to like explain in different like spaces, because when we think about these three different like terminologies, the way to tackle or the way to address these specific things will differ. So there is like a really challenge in Mexico and other countries just to be able to make that distinction and to be able to identify actually the cases that bear the hallmarks of SLAPPs. And the other thing I would mention is that in many cases, unfortunately, there is not a lot of media attention. And this is probably one difference with also global North countries, where there is a growing awareness about the uses of SLAPPs. There is a lot of coverage by media and so on. But in Mexico in particular, and in Latin America in general, just for the past maybe 2 or 3 years, there have been a little more like conversation and awareness about this, but there is not much coverage by media and by other organizations, also because, I mean, the levels of the security issues also the level of attacks against defenders in the country are higher when we talk about killings or disappearances. So this topic, for example, I mean, based on priorities for many organizations, maybe this is not something that they are able to actually focus. And I will just finalize with like maybe one or two things more about this difference between global north and global south countries. And the other thing that I wanted to highlight again is that the risk associated with people facing the SLAPPs in Latin America or in Mexico differed from like the level of risks that other defenders or people are facing in global north countries, especially when we talk about organized crime, for example, in Mexico, like defenders that are facing different forms of judicial harassment, including SLAPPs, they can be like potentially face other types of like lethal attacks in their countries. And finally, the other important aspect when we talk about these differences between global north versus global south is the legal protections, as I already mentioned, but also the support that the legal support or other support that people facing SLAPPs can have from civil society or from the government or from other people. It's really, I mean, it's really challenging in these jurisdictions. And usually when we talk about criminal cases, we talk about not only lengthy prison sentences, but also lengthy like proceedings. So for example, like 2 days or 3 days ago, we hear about a case in Peru that has been ongoing for 10 years, and people were like really facing like lengthy prison sentences, like for over like 12 years, 15 years. So it's really challenging when we talk about our legal system, our judicial systems in this part of the world, because usually, unfortunately, many of them are slower, weaker, and there are like so many aspects to have in mind in terms of corporate capture. So thank you so much for like the time, and apologies that it took more time than I was expecting, but I'm happy to answer any question.
No worries. I think your presentation was very insightful, so it's not a problem. It took a bit more time. And now I would like to pass the floor to Yogi Bharata Jaya to tell us something about the situation regarding SLAPPs in Indonesia.
Thanks, Susanna. Hi, everyone. My name is Yogi Bratajaya. I'm a legal consultant based here in Indonesia. I currently work with the International Commission of Jurists, but the views and materials I present here are on behalf of myself. It's midnight here in Indonesia. It's 12:25, but I am still wide awake, and I have been more than happy to hear and learn from the different jurisdictions and to present the Indonesian context within this webinar. As a bit of a disclaimer, I've noticed from my late nights that I've stayed awake that my internet likes to go out and reset during this time. So if I suddenly drop out in the middle of the presentation, you know why, and I'll try to quickly reconnect from my phone. But that's just like a little disclaimer. So on to the next slide. Thanks, Nancy, previously for providing the context and trends of SLAPPs in the Global South. Similarly to Mexico and Latin America, in Indonesia, these SLAPPs are also targeted not against, but the legal mechanism by which to carry out the SLAPPs isn't through civil litigation, while there are some, but it is mainly through the use of criminal provisions and criminal charges, and again, not targeting organizations, but targeting specific individuals and community leaders. So if the previous presentation talked about sort of the broad trends, challenges, and opportunities with SLAPPs in the region, in Indonesia here, what I would like to do is sort of, let's now get into the weeds of the actual specific provisions that both enable SLAPPs and also the specific anti-SLAPP provisions that have been enacted in Indonesia, also dispersing between them emblematic case studies on SLAPPs. So the first section here is on SLAPP enablers. And as I mentioned before, the main thing that enables SLAPPs in Indonesia is the criminalization of so-called defamation and false information provisions. So an emblematic law here is law number 1 of 2024 on the second revision on the law on electronic information and transactions, or what we like to call here is the ITE law. Now, there are two main provisions here that have been used in order to carry out SLAPPs against environmental human rights defenders. The first is Article 27A, which criminalizes, and here is the quote, any person who intentionally attacks the honor or good name of another person, so a criminal defamation law. And what was recently inserted within the second revision, so this was not in previous versions, is Article 28, Paragraph 3, and that is any person who intentionally spreads false information that causes public unrest. A violation of these provisions are sanctioned with heavy fines and or imprisonment. Here there are max 2 years for defamation and max 6 years for spreading false information. Now, a public interest defense is available for defamation, for the criminal defamation provision, and it protects, worded, I would say, quite broadly, the right to freedom of expression and democracy through rallies and criticism. So if it works as the law states, how it should work is that, you know, if the expression is a form of criticism, it should be protected. And these criminal defamation provisions shall not apply. But one thing to take in mind also is that the main goal of SLAPPs sometimes isn't necessarily to succeed on the claim or to get a conviction. As the name states, it's against public participation. So it's to send a chilling effect to dissuade and discourage other potential environmental human defenders or community members to speak out and launch any form of criticism against activities that would damage and pollute the environment. Now, the criminal defamation and these false information provisions are also included more broadly in the revised criminal code, which was enacted in 2023. So while the law that I provide here, I don't know if I can draw or not. So in the first bullet point, this law specifically applies to, you know, social media posts or anything over, you know, electronic transmission, while there are also broader provisions on criminal defamation and spreading false information in the criminal code. Now, why does this enable SLAPPs? You know, defamation provisions exist also in global north countries. Well, what specifically enables SLAPPs in Indonesia is that these defamation laws are worded broadly. So here from the formulation, it says intentionally attacks the honor or good name of another person, and also imposes an undue or disproportionate criminal sanction. If we were to take into account the standards provided by the United Nations Human Rights Committee or the Special Rapporteur on Freedom of Expression, they have provided consistently that defamation should never be subject to criminal as opposed to civil sanctions. Also, what I want to touch on and why I keep using hand quotes here to describe false information, because false information is usually like really hard to prove. And the lines between truth or false information is usually, or at most times, very blurry, and it can be subject to abuse by those in power. So here, Article 28, Paragraph 3 on the criminalization of disseminating false statements that cause public unrest is deemed vague, overbroad, and imprecise, which is inconsistent with the legality principle. This is a principle under international human rights law that states that laws that restrict the enjoyment of human rights, particularly the freedom of expression, must not be formulated in an overbroad or vague manner. They must be worded specifically. So here is the first emblematic case of the use of these two provisions, of the criminal defamation and the false information provision. And this is the criminalization of two prominent human rights defenders, Haris and Fatia. These two human rights defenders were criminally charged with defamation and spreading false information. The complaint was filed by the Indonesian Coordinating Minister for Maritime and Investment Affairs, where the complaint concerns a YouTube video that the defendants made discussing research results from a report by 9 civil society organizations, in which the report discusses certain allegations of the involvement of the Indonesian army officials and retirees in plans to exploit gold in Papua. The video specifically drew attention to allegations relating to the minister, the one who filed the criminal charge, scrutinizing potential conflict of interest due to his position as the minister at the time. Now, after lengthy trial process, I was there trial monitoring, but this lasted for around a year. Fortunately, both defendants were acquitted by the district court, where the court held that the statements in the videos constituted analysis, opinions, and assessments based on research conducted by a civil society coalition. The judges here referenced and based their opinion on a joint decree. This is a joint decree enacted jointly, for lack of a better word, by the Minister of Communication and Information Technology, the Attorney General, and the Chief of the Indonesian Police. And the joint decree stated that an action shall not constitute a defamation offense if the content, in quote, is in the form of an assessment, opinion, evaluation result, or if it is a fact. So here is a crucial defense regarding defamation in providing truth as a defense. So if a statement or criticism or other form of expression provided is true in fact, it shall not be deemed as defamation. What is not sort of concerning, but the downside of this, while this joint decree is very welcome, the joint decree itself isn't actually legally binding. It's more of like guidance for these three agencies that enacted it. In the closing statements, the court emphasized that Indonesia is a democratic country that upholds the right to freedom of expression, and that public officials must be prepared to receive criticism about their personality and their work. So a happy ending to this case. However, it has to be emphasized that the case should not have proceeded to trial in the first place. The mere fact that this case even went to trial sends a chilling effect for environmental activists, particularly those directly criticizing powerful members of the regime, so political or business elites. It sends a chilling effect in a sense that the trial went on for a while and, legal costs were involved. And so it sends a chilling effect for others who potentially, would like to express themselves, provide criticisms against environmentally damaging activities, to not speak out, or else be prepared to go towards this lengthy trial and face the harsh sanction of imprisonment and/or heavy fines. Here we have the second emblematic case. But before I go to this, I'd like to actually go to this slide first so we can better understand that second case. And this is the existence of anti-SLAPP laws and regulations within Indonesia. So in Indonesia, there is no legal provision defining what a SLAPP is, but there is a legal provision that provides protections against SLAPPs. Now, I wrote down the 7 or 8 criteria that James provided. So let's all look at the relevant regulations and laws, and let's test them against these criteria. So the main legislation here is Article 66 of Law number 32 of 2009 about environmental protection and management, which states that any person that struggles for the right to a satisfactory and healthy environment shall not be criminally charged nor sued in civil litigation. And James, please interrupt me if I miss any criteria or I misrepresent them. But the first criteria is the scope. And the scope here would be regarded weak as it only provides protections against environmental cases and environmental matters. It doesn't provide broadly against, say, SLAPPs against labor rights activists, which criminal defamation provisions have been filed against labor rights activists and women's rights activists. So this law is implemented through Supreme Court Regulation number 1 of 2023 on guidance for managing environmental cases, which provides judges the authority to dismiss SLAPP lawsuits and also provides guidelines on how to identify SLAPP lawsuits. Here, the respondents or the defendants may file a motion to dismiss a legal claim or criminal charge before an examination of the merits. So, another criteria is, does the law allow for the motion to be dismissed and stay proceedings? This regulation would say yes. Upon receiving the motion, judges may issue an interim decision dismissing the claim, and that has to be made within 30 days of
I think there might be a technical issue, as Yogi has told us before. So maybe Zuzana, you may want to.
Yes, thank you. Sorry, I didn't want to say anything because I thought maybe it was on my side, but that's okay. So yeah, once he's back, I think we'll let him finish his presentation. And in the meantime, we have a question in the chat for, sorry, it's for James Stark. This is a question regarding the, judicial training. So Kelia wants to know if the promotion of judicial training could help set the stage for wider reaching mechanism like those implemented in Quebec against improper procedures.
Is that directed to me?
Yes.
We don't have the practice of judicial training on this in Canada, but in another area in which we do a lot of work around whistleblower protection, arguably one of the most best laws for whistleblower protection is in Serbia. And one part of it and what makes it work is it requires judicial training of judges who will be handling whistleblower cases. And that's resulted in a significant improvement in the outcomes for the law to protect whistleblowers. So I imagine that there's enormous advantages to implementing a provision for judicial training, although we haven't done it.
Hi. Yeah,
Thank you
there
so
it
much.
was.
Okay, we have
So
Yogi.
Hi.
Sorry, we
So
skipped
my
the Q&A.
internet cut out. Sorry about that. Can you all hear me clearly?
Yes.
Okay, so I'll proceed. Hopefully it doesn't cut out again, but yeah, unfortunately, this is something that regularly happens. So where were we? Yes, dismissing the claim within 30 days of receiving the motion. So in the criteria of does this provide for the scheduling of expedited hearings, I would say yes. I mean, I don't know what the criteria is from James on like what the ideal time frame would be, but in Indonesia, at least 30 days is considered rather quick to dismiss, for a motion to dismiss. During trial, defendants may use SLAPP as a defense. So they have to prove to the court that they are in fact an environmental human rights defender. And then within 7 days of receiving the motion, then the burden of proof shifts to the plaintiff or the prosecutor to prove that that the motion should be accepted. So on the criteria of the shifting of burden of proof, I would say yes. However, the regulation doesn't provide specifically the standard of proof that is to be used, whether it be preponderance of evidence or without reasonable doubt. When assessing a motion to dismiss a SLAPP lawsuit, judges shall take into account factors such as the right to enjoy a satisfactory and healthy environment, the right to receive information, public participation and access to justice, and proportionality between the public interest that is being defended and the allegation of unlawful or criminal activity. So, this is, I think, the final criteria on is the provision interpreted broadly. I would say that these are pretty broad interpretations. The regulation further specifies that what constitutes as an activity of an environmental defender rather broadly as I wrote it down here. It can be, filing civil suits, administrative suits, or criminal charges in relation to environmental protection, or broadly expressing an opinion in public through the press, social media, and any other forum. Now, another criteria is, does the act contain, or does the regulation or law contain a damages provision? Here it's yes for civil cases. So if when succeeding on their motion to dismiss, the respondents can also file a counterclaim to claim damages that will be awarded to them should they succeed, on the counterclaim or on the motion to dismiss. So that's also a tick in the criteria. So just a few comments. It would seem that this would be a pretty strong law and regulation. Although, of course, the effectiveness of this provision depends on its application and implementation. And here we see, can I have control to move the slides? Or can you move back one? Maybe you can just do it. Oh, here we go. Yep, here is an emblematic case of that. And this is the criminalization of environmental human rights defender Daniel Tangkilisan. He was convicted of violating an overbroad hate speech law under Article 28, Paragraph 2 of the ITE law for posting on social media. This was a Facebook post that called out environmental pollution caused by waste from illegal prawn farms in the Karimun Jawa Island. So he was convicted guilty and sentenced to 7 months imprisonment by the district court. On appeal to the high court, he was acquitted based on a finding that he was lawfully exercising his right as an environmental activist. What is peculiar about the decision by the high court is that although why they acquitted or exonerated him from the conviction and from the criminal sentence, the court still agreed with the lower court on finding that the statements constituted a violation of the hate speech provision. So they still found that the post constituted hate speech. But they provided that, since he was doing so in accordance with Article 66 of the Law on Environmental Management, the law we mentioned here, he was acquitted and released of all criminal charges. Just a few comments on the law on hate speech. Again, the criminal defamation and false information law that I mentioned is only one of a broad array of provisions that have been used to silence or curtail freedom of expression and public participation, particularly in environmental matters. Another another problematic law and another emblematic case is there was an environmental activist who attended a peaceful protest against gold mining. He was detained, criminally charged, and convicted of violating a law protecting the security of the state. He was imprisoned for peacefully protesting a gold mine, for the reason that allegedly he had posters displaying the hammer and sickle. He was convicted of violating Article 170A of the Criminal Code, which prohibited displays of communism and Marxism-Leninism. So a really McCarthyist law, a very Red Scare law, which when I read about that in the news, I was also still surprised that it still existed. But this is just to demonstrate that although within this specific presentation, I mentioned these two laws, which are the main enablers of SLAPPs, there are other, not just criminal provisions, but also, contempt of court provisions that have been used against environmental defenders and activists. And again, although there have been some positive developments in the enactment and implementation of anti-SLAPP provisions, this is only one small part of creating an enabling environment for environmental human rights defenders. Similarly, as Nancy mentioned, they also face, threats, intimidations, and in the worst and most fearful instances, even killings of environmental human rights defenders. And so, thank you very much for listening to my presentation. I apologize once again for my internet cutting out in the middle, and I'm happy to receive and answer any questions. And James, of course, feel free to comment on the presentation. If from looking at that provision, you find that there can be any improvements, I'd be happy to incorporate that in my work and if possible, provide recommendations to the relevant authorities.
Great, thank you. Maybe I will pass the floor to James to answer that, comment on that.
Are you asking me to comment on what Yogi just mentioned?
Yeah.
Yes. So I found it very interesting and in one sense feel badly when we did our survey of anti-SLAPP laws. We looked at things that were defined or described as anti-SLAPP laws, but there may be provisions like the ones you described that are effectively anti-SLAPP laws with regard to a more focused application that we should have included, and will do so for the next one. So I found that very interesting. As well, with regard to several of the criteria that you identified, I think you identified them correctly. In our case, in the Ontario case, the deadline for a decision by a motions judge to dismiss a case is 60 days, but that's never honored. We have such a backlog of cases in our courts that while that law says that, it often is 120 days or 180 days. So, but we find it still useful to have it specified in the law. That's the objective, because it makes it easier to put pressure on the court to act expeditially. So getting it done in 30 days is very fast indeed.
Great, thank you so much. Nancy, I see your raised hand.
Yes, I have a question for Yogi. Thank you so much for the presentation. And as you mentioned, I mean, sometimes is not only having the law, it's also to see, I mean, if the law has been applied. So I wonder if you know if this has been applied in any specific case or in any of the cases you shared. But also apart from apply, if like the time that is mentioned there, for example, these 30 days has been effectively like applied, or because usually in global south countries we have so many delays. So I just wonder, I mean, to what extent the law has been effective or not. But it's fine if you don't have the information, but I'm just curious to know more.
Thank you. Yeah, so it was specifically applied in the second case that I mentioned, Daniel Fritz. The court held that although this does constitute an unlawful speech, hate speech, the broadly defined hate speech, they still acquitted him because Article 66 applied. So the anti-SLAPP provision that I mentioned. Now, in the first case that I provided, again, there are inconsistencies, I would say, in its application, which does sort of halt its effectiveness. And this can be due to several factors. I assume, and I'm not stating this as a fact, in case I get slapped myself, that that it's due to collusion, between higher powerful entities in politics and business and the judiciary and the the justice sector actors. But within the first case, this was an example of the provision not being applied, because what made the court acquit Haris and Fatia wasn't a determination that the expression constituted a lawful act of, defending the environment, but simply because the elements of defamation weren't fulfilled, and that the expression constituted a valid, fulfilled the public interest exception from reading the judgment. So yeah, it's good, but it has been, inconsistently applied. Again, it's up to the discretion of each judge and court, right? Whether they want to apply it or not. But yeah.
Thank you so much. We have another question. This time it's in the chat, and it's to Lady. It's from Nicola. It's quite long, and if Nicola is with us, maybe you would like to ask it yourself.
Actually, I read the question, so I'm happy to answer the question.
Okay.
But yeah, this is a really hard question. And honestly, I don't know if I have a good answer to it. Because, yeah, I mean, the level of corruption and collusion and so on in Latin America and in Mexico is so high that it's hard to think about a good practice that can be used in other jurisdictions. But maybe something important that we constantly see in this region is the involvement of civil society organizations and giving them a space to be consulted, to participate, to comment. And that is like important and something that can actually help eventually to prevent like this kind of collusion, or at least to speak out against this. Is like something that we see as a tool and practice in Latin America. And the other important thing to have in mind is like everything related to funding, but also related to, I mean, what funds people can access, for example, to defend themselves on anti-SLAPP laws and so on. But something specifically related to Mexico is that one of the main critiques about the mechanism to protect human rights defenders and journalists in the country is that that specific mechanism, unfortunately, doesn't have funds. And it operates with a lot of limitations. So if there is any sort of mechanism in France or something like that, I think one of the most important things is also to make sure that that mechanism or that institution or that body whatever the fort it takes potentially in France, has the funds to operate and to work, but also to have the technical expertise, because this is the other issue in Mexico and in other Latin American countries, that is not only having the funds, the economic resources, but also having the human resources ready to work and to support. So there are just like few examples from the region that I see that can be important to maybe, I don't know if replicate, but at least that can help like these kind of conversations in other jurisdictions, including France.
Great, thank you so much. And we have one more question in the chat, and it's from Vincent. Again, Vincent, maybe you'd like to ask it yourself.
Yeah, thank you, Susanna. So yeah, there was a question for James. So you mentioned that the Protection on the Public Participation Act, especially in Ontario, entails a broad scope of application, and notably that the definition on of expression is broad. And from our work, we've identified, like in other instances, that broad legal framework and definitions have led to misuse of laws and sometimes political interference to impose an interpretation on the judiciary, the judiciary. And so I was wondering if you think that the broad legislative scope in this case could lead to such political interference to give like the law or the judiciary to impose like a certain understanding, if you see any unforeseen unwanted consequences, or if there has been criticism deriving from this broad legal framework.
Thank you very much for your question, Vincent. I mean, generally, we're concerned about broad or vague language in law. In this instance, it actually works well, because what it's saying is that the protection, that is the ability to bring a motion to have an inappropriate legal action against you, is broadly defined. So it gives a lot of opportunities for people to bring forward instances where a narrow definition would allow them to be attacked successfully. So if it arises from defamation and is any form of lawsuit, then you have the right to approach a motions judge. What prevents it from being abused are the subsequent criteria that the motions judge has to apply in deciding how to adjudicate the issue. And as I mentioned, the first requirement was the defendant having to persuade the judge that it's a matter of public interest. And when the law was first brought in, because it was so broad, there was a fear that the judiciary would be reluctant to impose it. That is, they would say, everyone has the right to their day in court, and so the person who is suing you has a right to have the whole case heard in detail. And so the first couple judgments applied a very unreasonable standard as to whether it was a matter of public interest. In other words, they applied a very high bar, so it turned down initial motions. And then the next ones were decided appropriately, and all of them were then challenged in court and went all the way to our Supreme Court, which upheld the intent of the law. That is, your right to be protected broadly, to bring forward a request for a motion, is appropriate, but the judge then has to apply the standards first on the defendant about what public interest is appropriately. That is, if it's clearly a matter of public interest, then the defendant has met their obligation. And then it's a very precise obligation on the plaintiff, as I mentioned. That is, they have to show that they have been seriously harmed. Secondly, they have to show that the defendant has no legal defense. And they have to show that they have to convince the judge that the public interest in allowing the lawsuit to proceed outweighs the public interest in protecting the defendant's freedom of expression. So those are three very strict standards that the plaintiff has to meet. And typically for most SLAPP suits, they cannot. And so it leads them. So it's broad to get into it, but then it's very specific once you're in it. I just should say, Vincent, in answer to your question, our analysis of these 37 anti-SLAPP laws was based on the wording of the law. We're now undertaking a second study, which is a more difficult one, to see, does the law on paper translate into effective protection. And so we have law students who are looking at least the 7 top jurisdictions to see whether what looks good on paper actually translates into real protection. And that will be a very valuable report, but it'll be a couple of years till we have that done.
Thank you for your answer, James. Maybe I give the floor back to Susanna for a last comment, maybe before closing the webinar.
Yes, I also wanted to thank you all for the interesting discussion. As you know, I work for the Foundation for Human Rights in Poland, and we also are engaged in the implementation process of the anti-SLAPP directive. So these remarks were also very interesting for me and for my personal or more professional, let's say, endeavors. Also found what Yogi said extremely compelling. In Poland, defamation is also still criminalized, and we were in talks with the Minister of Justice to maybe convince him to decriminalize defamation in order to properly implement the directive and properly counteract SLAPPs. Nevertheless, I hope that it's always very, very compelling to see how other countries and human rights defenders from other countries deal with this issue. So I would also like to thank you very much for the conversation.
Thank you, Susanna. So just to wrap up the event, I would like to thank all the speakers and moderator today. We really appreciate that you took the time, and especially given the circumstances for some of you, Yogi in particular, for the time zone. If you have any further question, because the discussion was not as developed as we would have liked it to be, potentially you can write to us at the email address contact@grossington.org if someone from my team can put it in the chat, and we will circulate it to our speakers, and I'm sure that they will be very happy to discuss. And for the speakers, we will also put you in touch among you so that you can maybe continue the discussion. Just to inform everyone, so this was the first event of a series of 3. The objective for us is to create and draft a policy brief that gathers recommendations to inform policy recommendations in the context of France, with an ultimate, like a third event that would be a more advocacy-like event, with hopefully the engagement of parliamentarians in France. So we will keep you posted about the future events. And if you would just like to answer maybe our feedback form concerning the event, it will be put in the chat by my team, but we will also send it via email to all attendees and panelists. So you don't have to do it now if you need to go. Yeah, that's it on our side. Once again, thank you, everyone. And I wish you a great evening or a great day, depending on where you are, or a great night as well for you, Yogi. Bye, everyone.
Thank you so much. Bye-bye.